Ever heard of something called split care and control in divorce cases? It's rare, but here's how it works. Split care and control means each parent has primary care of one child and is only granted under specific conditions. Courts generally avoid splitting siblings unless it maintains an existing stable arrangement. For example, number 1, court preference. Courts prioritize keeping siblings together, especially if they share a close bond and live well with one parent. Even when one parent requests split care and control, it's often denied if it risks disrupting the children's stable environment. Number 2, established arrangement. In rare cases, split care and control can be granted if children have been living separately with each parent or under different care arrangements since birth. Courts aim to maintain this arrangement if it serves the children's best interest. Number 3, supportive orders. When split care and control is ordered, additional measures may sometimes be implemented to support the relationship between each child and the parent they don't live with, often involving Divorce Support Specialist Agency or DSSA services. Ultimately, split care and control is carefully considered and only used when it really aligns with the children's welfare and existing arrangements. Ever wondered what child access means in a child custody situation? Here's how access orders work in Singapore divorce cases. Access is the court-granted right for a child to spend time with the parent who doesn't have care and control over him. Most orders allow for something called reasonable access, giving parents the flexibility to work out schedules as the child's needs change. Sometimes a parent may prefer a specific schedule covering important times such as birthdays, public holidays, or school breaks. If parents can't agree on access terms, they can bring the issue to a judge during the ancillary matters hearing. Access orders typically fall into 2 categories. Number 1, standard access. This allows unsupervised time with the child. Number 2, supervised access. This is imposed to protect the child from potential harm or to support and assess their relationship between child and the non-custodial parent. Supervised access may also include counseling to help build a positive parent-child relationship where it's needed. Ever heard of something called an access evaluation report in a divorce case? Here's why it matters for child access arrangement. An access evaluation report helps the court decide on the right type of access order, especially when supervised access is under consideration. This confidential report, prepared by a professional, gives the judge some recommendations. Number 1, duration of access. How long and how often the non-custodial parent can spend time with the child. Number 2, the need for supervision. Whether access should be supervised, and if so, under what conditions. Number 3, when supervision can be lifted. Guidelines for transitioning to unsupervised access if it's deemed safe. The report is strictly for the judge's review and it isn't shared with parents or even lawyers. It ensures that access decisions prioritize the child's safety and welfare. What's the deal with child and spousal maintenance in Singapore? Here's what you need to know about financial support in divorce cases. In Singapore, maintenance refers to financial support for a child or spouse, typically paid monthly. For child maintenance, payments usually continue until the child turns 21, although the court may extend this if the child is in national service or in higher education. Maintenance can be ordered anytime during or after divorce proceedings to ensure the child's needs are met. Spousal maintenance. The wife, or in some cases the husband, can also apply for support, with payments often stopping if she remarries. Factors the court will consider include the following. Number 1, the financial status and standing and needs of both parties. Number 2, the marriage duration and the living standards previously enjoyed. Number 3, contributions to homemaking as well as family care. Husbands can also apply for maintenance if they are unable to work due to a disability. Payments may be ordered as a lump sum or monthly installments, with lump sums preferred for a clean break where it's financially possible. What's the court's aim when it does this? To ensure that both parties can maintain a reasonable financial position post-divorce, reflecting their pre-divorce standard of living. Did you know that all parents, including step-parents, may be legally required to pay child maintenance in Singapore? Here's how it works. In Singapore, child maintenance is a legal obligation for biological parents, adoptive parents, and sometimes even step-parents. Maintenance duties apply regardless of marital status, legitimacy, or where the child lives. Here's a quick breakdown. Number 1. Biological parents. The court upholds maintenance obligations for both legitimate as well as illegitimate children. Biological parents must contribute to their child's upkeep, regardless of marital status or remarriage. Number 2. Adopted parents. Adoption gives a person the same maintenance responsibility as a biological parent. Number 3. Step-parents. If a step-parent has accepted a child as part of their family, they may be required to provide maintenance, especially if the biological parents fail to do so. However, this duty generally ends when an interim judgment for divorce is granted or if the child is removed by the biological parent. This approach ensures that every child's well-being is always safeguarded, holding those who accept parental roles accountable for their financial support. Need financial support for a child under 21? Here's how to apply for child maintenance in Singapore. Eligible individuals for child maintenance include guardians, siblings over 21, or any appointed guardian. Once the child reaches 21, they must apply independently. When deciding on maintenance, the court considers many factors, including the following. Number 1. The child's needs and standard of living prior to financial neglect. Number 2. The parent's financial resources and contributions to the family. Number 3. Education or training anticipated for the child. Maintenance orders usually end when the child turns 21, unless they have a disability, are in national service, or are still studying or training. Applications can be made through something called a maintenance summons or application in the family justice courts, or online, even before a divorce is finalized. These provisions ensure that each child receives necessary support for their well-being and their future. Can child maintenance orders be changed? Here's how variation of a child maintenance order works in Singapore. Child maintenance orders aim to serve the child's best interests, but either parent can apply to modify them if significant and material changes occur, such as, number 1, changes in the financial situation. A parent's employment status or shifts in the child's medical or educational needs can sometimes prompt a variation request. 2. New family responsibilities. If the paying parent remarries and gains new financial responsibilities, the court may consider adjusting maintenance if obligations to both families have been met reasonably. Number 3. Rising cost of living. The court may adjust for inflation but won't increase maintenance for expenses considered unreasonable or self-imposed. A variation won't be granted if the paying parent creates their own financial difficulties, such as voluntary unemployment. For spousal maintenance, the court may approve adjustments if misrepresentations were made or if a material change in financial circumstances arise. These guidelines help to ensure maintenance always remains fair and supportive of each family's evolving needs. What happens if a parent fails to pay child or spousal maintenance in Singapore? Here's what you need to know. If a spouse breaches a maintenance order, the Family Justice Court can enforce payments for overdue payments. The applicant must then provide a couple of things. Number 1, calculations, a table of months unpaid and amounts owed. Number 2, bank statements, proof of payments made and those that were missed. Number 3, expense documentation, receipts for child-related expenses such as school fees and medical costs. Once verified, the court may then order payment as a lump sum or in installments. Failing to comply can lead to serious consequences, including the following: fines or jail time, up to 1 month even, per unpaid month; community service, up to 40 hours, as well as a credit report impact, reporting to a credit bureau, which can harm the defaulter's credit rating. So remember, jail time or imprisonment doesn't erase the obligation to pay. The debt still remains. The court also has the power to issue something called a garnishee order, directing a third party to pay the amount owed directly to the child or to the spouse. These measures ensure compliance, emphasizing the importance of meeting court-ordered maintenance responsibilities.